You are Mr. Witsy, is that correct? Okay. Mr. Witsy, you, I assume, have sat through some of this morning. You've seen the procedure, the way we operate here?
Yes, I think I have a good idea.
Okay. Do you have any questions about anything?
No, sorry.
Okay. You understand when we begin this, you'll have 15 minutes to make your oral argument. Now, if you would like, you can reserve up to 5 minutes of that time to come back and have rebuttal time after the other side makes its argument. And when you come up here after you've introduced yourself, by that I mean after you told us who you are, you can reserve up to that 5 minutes of rebuttal time, so be thinking about that. We have a preliminary matter that we need to resolve. Mr. Witsy had filed a motion to extend his oral argument time, which we have denied, but he's also requested that this oral argument not be live streamed or put up for view on the internet. I don't believe your clients have filed a response to that, have you?
No, sir, we have not. We would object to the extent that we could do it in this form. We would object to the request to not live stream, to not put it on the internet.
Okay. At this juncture, we're not going to live stream it. We will video it. I will give you an opportunity, both of you, within 5 days to file a written objection, because that's what we have to go by here. And then the court will make some determination about it based upon the pleadings. You understand that, Mr.
Yes,
Witsy? We're not going to live stream it today. In other words, it's not going out right now. Okay? All right. Thank you. Thank you. Mr. Witsy, anything before we begin the argument?
No, sir.
All right. If you would, please, sir, come up here. And if you'll introduce yourself and let me know about the rebuttal time, and then we'll start the time on the timer.
Okay. My name is Derek Witsy Jr., and I would like to reserve 3 minutes.
3 minutes. All
Yes,
right,
sir.
sir. Okay, you may proceed.
Okay. This case is in appeals because the lower court failed and refused entirely to provide any facts of law and evidence that there was anything wrong with my claim, with my argument. Instead of providing any facts of law to challenge anything I said, the lower court, he stated that he wasn't there to give me a school lesson, and he left it at that. So the appellees failed to give any argument, and the chancellor failed to give any argument or evidence. So moving on from that, I found it very interesting that the appellees requested this oral hearing, seeing as how they stated that my brief was incomprehensible. If they truly felt that way and was confident of that, why would they want to waste their resources showing up to court? Seems like they would be confident enough in what they said in their brief alone. But instead, they wanted to come here to give you all 30 minutes of argument about things that they have not said at all. I want to keep in mind here for the court some foundation critical errors that they have to overcome here. The black and white evidence requirements, black and white legal documentation. Number one, black and white evidence that Tamika Cole was actually a borrower in the contract. Black and white evidence that she didn't just grant away and deposit over $200,000 cash value. Black and white evidence that she claimed the title to the property within 1 year as required by statute. Evidence that she was a party to a lawfully binding agreement. And black and white legal documentation and evidence that she protected the title from all claims and demands, which she was obligated to do under the deed of trust. Without these foundation black and white documentation, there is nothing that they can say here in the next 15 or 30 minutes that's going to be enough to prove their case, because this black and white evidence is actually required. There is no oral argument that would be sufficient enough to substitute for these requirements that they've had the past 2 years to submit. So moving on from that, I think it's pretty clear that this request for an oral hearing was their last desperate cry for a lifeline from the court. But moving on from that, we already know what they're going to talk about. They're going to talk about the certificates of acknowledgement, Civil Procedure Rule 9, the brief deficiencies, and whose name is on the deed. About the brief deficiencies, they're going to nitpick about the title page, whose name was on the title page, appellant and defendant in this place. They're going to talk about the citation of authorities, which they were provided with and given the opportunity to respond to per Rule 27D. But I want to make a note about that. It's not enough to just cite a bunch of authorities. You have to be able to cite authorities that actually help your argument, that actually benefit your argument. It does no good to cite authorities that your opponent can actually use against you, which, as you all seen, I did several times. They just handed me authorities that I could use against them repeatedly. Specifically, Glankler, they're going to state about, well, I'll come back to that. So that's about the citation of authorities. Civil Procedure Rule 9, they're going to talk about how I didn't spell out fraud good enough against them. They're going to say I didn't state it with particularity, I didn't make it clear enough. Despite the fact that I showed this court and the appellees from pretty much every conceivable source how they committed fraud, how fraud was committed. I used the terms and conditions of the deed of trust itself, state law, federal law, the Federal Reserve, even though we know the Federal Reserve is not a federal agency, but they are backed up by federal law, equity maxims, bank law, trust law, property law, contract law, literally all of those sources combined into this case, I have used and shown these courts how fraud was committed. With regards to Glankler and using that argument, they're gonna say that I didn't spell it out well enough against them. Well, we attacked that head on. That $250,000 that I'm asking the court to give back to them for the foreclosure sale, that all comes to me. Since they insist on me including them in the fraud, that $250,000 for that property comes to me.
Why does it come to you? Why don't you just explain that to us
Okay.
first?
Well, since they're saying that I didn't state fraud specific.
Why do you get a chance to state anything if you're not a party to any of these agreements at all?
Well, I was a party to the agreement.
How were you a party to the agreement?
Well, I claimed ownership over the title to the property.
And
That
how do you do that?
the certificate of acknowledgement.
What is that?
The certificate of acknowledgement, without that document, there is no claim of ownership. That is the evidence that you have a claim of ownership over the instrument.
Do you know what a certificate of acknowledgement is?
Yes, sir.
So what is it?
Well, the certificate, it is acknowledgement. In that instrument, you are acknowledging the instrument, the deed instrument. You are acknowledging the claim of ownership over the deed instrument.
Is it a deed?
Excuse me? The certificate of acknowledgement itself is not a deed.
So where's your deed that gives you an interest in the property?
Well, the deed itself is the central of this, the central part of this case, in that the deed itself in question was abandoned. Per state law, there was a requirement for that instrument to be claimed within 1 year before it was considered abandoned. So because there was no,
Let's assume it was not claimed by the owner. What gives you a right to claim it?
well, I was going to get to that in my main points. So
You can argue it now. What gives you a right to claim it?
well, number one, consent and agreement was given to me by the appellees that I could claim an interest in the property. Through the notice of trustee sale, consent and agreement was given to me that Whitsey could claim an interest in the property. The title to the property represents full ownership interest in the real property. There was no claim of ownership interest in that real property. Consent and agreement, like I said, through the notice of trustee sale was given that I could claim that. Tamika Cole was obligated through the deed of trust to protect that title from all claims and demands. No evidence to the contrary was given that she actually did that from her or from the appellees. There was no ownership, there was no evidence given that there was any claim of ownership. So she had a two-part obligation: to claim the deed within 1 year per state law and to protect the title from all claims and demands, both of which she failed to do.
And how does that impute an interest to you because of what assuming she failed to do something? How do you get an interest in that property because of what she failed to do?
Well, her failure to do that means that the property became abandoned. So when you have abandoned property, a third party can come and claim that abandoned property. So that's like basic property abandonment, 101 on that. So because she failed to perform.
How does that work? Because this is real property. This isn't personal property.
Well, the deed instrument is considered personal property. It's a public record, like you all were hearing about earlier, talking about public records. The definition of property, as I cited in my case, a fixed or certain interest in intangible property held by a government instrumentality. So the deed instrument, intangible property, representative of ownership interest in the real property, was held in tangible form by a government instrumentality, the Register of Deeds. So the deed of trust that they've been referencing the entire time is also held by a government instrumentality, the Register of Deeds. So there is no like legal wordplay to get around that. They have not provided any physical copies. They've done nothing but reference.
So you're saying you've got an interest in the deed?
Yes, sir.
The deed was abandoned. The piece of paper was abandoned.
Yes, sir. Yes, sir, which represents.
How does that relate to the real estate?
Well, the deed itself represents a full ownership interest over the real estate, over the real property.
It's just a way to transfer property.
Well, the deed was granted, excuse me?
It's a piece of paper.
Well, respectfully, I have to disagree with that because the deed instrument.
You have the right to do that.
Yes, sir. Well, the deed instrument was granted away. It represents property, a grantee. So there's grantor, grantee language on the instrument. So the deed itself represents a title to the property. And there was a requirement for that deed instrument held by the Register of Deeds to be claimed within 1 year before it was considered abandoned. So none of them, the lower court or the appellees, provided no argument or evidence contrary to this. So
Who granted you the interest in the property that you're seeking?
Well, no one had that's one of the arguments I made. None of them had the power, Tamika Cole or the bank had the power to grant the property to anyone.
If you were to go over to the Register of Deeds office in, I guess it's Shelby County, and you were trying to ascertain who the record owner of the property is based upon the deeds that are registered there, who would be the owner of that property today?
Well, there's a parent owner and then there's owner. And that's another part of the argument I made. Tamika Cole was only an apparent owner, but she was not the actual owner of the instrument. So you got the record holder, then you got the actual owner. I provided evidence that I was the actual claimant and owner of the instrument.
And where do you get you being the actual owner when it never was transferred out of her name, following your argument here?
What do you mean transfer out of her name?
The property was transferred to her. How did you get it from her?
Well, the thing about it is she had an obligation to claim that property that was supposed to have been transferred to her. Part of the argument I've made, she never claimed ownership over that property.
What did she have to do to claim it?
Well, part of the registration requirements is when the deed instrument is registered, there shall be registered as well the certificate of acknowledgement with the certificate of authority. So she was supposed to claim the certificate of, she was supposed to use the certificate of acknowledgement to claim that instrument. Because you can't force property onto someone without breaking the law. They have to consciously accept that property themselves under their own free will act and deed. So the certificate of acknowledgement is the documentation that would have been proof of her claim of ownership over the deed instrument. So there is no other instrument that will be statutorily recognized that would allow her to do that. So because she didn't do that, she failed the most critical duty in the whole transaction, which gave them the right to do the foreclosure sale, which was unlawful. And so
So why does the ownership fall to you as opposed to anyone else?
because I'm the owner of record of the property. I'm the owner of the deed instrument to the property. I became the grantee of the deed instrument. So there is no owner of the deed instrument as required by state law. It was abandoned. The deed instrument is representative of ownership interest over the real property. I claim that ownership interest over the real property. So no one else provided any evidence or proof of claim to the property. Their best proof of claim of ownership was the deed of trust, which they failed to give any arguments for. They're trying to convince the court that Tamika Cole borrowed money when I provided evidence that she granted away and deposited money. Granted away over $200,000 worth of cash value, but they want you all to believe that she borrowed over $100,000. But they provided no evidence that she actually did. I provided contrary.
Did Ms. Cole contest that?
Excuse me, sir?
Did Ms. Cole contest that she received the money and that she signed the deed or the deed of trust?
She didn't contest anything either way.
Then how can you contest it on her behalf?
Well, it's not really on my behalf. I'm just pointing out what's already on the record.
On her behalf. She's got to be the one who contests it.
Well, if the deed of trust is a central part of the argument and both of them are using the same instrument, they're trying to use it as evidence, but I also use it as evidence that they don't have a claim of interest.
Okay. You used your initial time. You can have a seat and you can have your rebuttal time of, I think, 3 minutes. Gentlemen, I assume you are splitting your argument, or?
There we are.
Okay.
I'm Richard Myers. I represent the Appalese Belgravia Square LLC and RA Oakline LLC. Mr. Giddings represents Midfirst Bank. My time won't be very long. Most of what we said, need to say is.
Well, I need a
brief.
specific number.
I will
so
take 5 minutes.
5 minutes?
Yes, sir.
Okay. All right, sir.
The subject property, that's the focus of this entire issue, the complaint, is 7012 Oakland Chase, Memphis. R.A. Oak owns it. R.A. was deeded the property by Belgravia, which bought it at the foreclosure conducted by Midfirst Bank. My clients were sued by the appellant in his amended complaint. There was no cause of action alleged against R.A. Oak in the amended complaint or the original counter complaint. And so the trial court properly dismissed the amended counter complaint against R.A. Oak, and we asked this court to affirm that. There is no cause of action asserted against him. The bare allegation against Belgravia by the appellant is that Belgravia, quote, participated in a fraudulent transaction with Midfirst, and thereby, according to the appellant, stole Witsy's property. That's the basis of really the appellant's entire case, is that he had a property interest and it was stolen. The bare allegation of fraud against Belgravia is legally insufficient to state a claim of fraud. Rule 9.02 is very clear that you've got to plead with particularity the specifics of fraud or you get it dismissed. Case law is actually what says you get it dismissed. Both Diggs v. LaSalle and Harmon v. Trinity, which we cited in our brief, state that the pleading with particularity requires stating what was false. How did Belgravia know it was false? And was the falsity material? Did the appellant rely on it to his detriment? The purpose of pleading with particularity is to require facts of fraud, not speculation on facts of fraud. And the appellant's bare allegation here does none of what Rule 9.02 requires. And both Rule 9 and case law state that, or actually case law states that dismissal is proper for failing to plead with particularity. And we asked the court to affirm the trial court's dismissal of the amended counter complaint against Belgravia. The other issue, which the trial court dispensed with as a matter of law, and it really is the core of the appellant's entire effort here, is that the appellant had no property interest. He didn't own the subject property, so nothing was stolen. There's no record owner executed a conveyance deed to the appellant, and the appellant's claim that the proof of his ownership is a certificate that he filed claiming that the foreclosed owner, Tamika Cole, abandoned the property, and he cites the Uniform Unclaimed Property Act at 6629-101 at SEC. According to that statutory scheme, the only defined property interests that can be abandoned and therefore claimed by the appellant are property interests that are defined in 6629 at 101 at SEC. Those property interests are defined in 29-102 and 105, and real property owned by a live person, which is what we have here, is not included in the list of property that can be abandoned and therefore claimed. So the appellant's basis for his entire effort here, the certificate that Tamika Cole abandoned the property, is legally meaningless. And we asked the trial court, this court to affirm the trial court's very proper dismissal of the amended counter complaint against Belgravia and R.A. Oak. Any questions?
See none. Thank you.
4 minutes. 4 minutes, not bad.
Good morning. If it pleases this court, I'm Joel Giddens. I am here for Midfirst Bank instead of Mr. Morrison, who is my partner. We are here simply because this action got initiated in the lower court for an interpleader after a duly conducted foreclosure sale to pay excess proceeds to interested parties. Mr. Whitsey was an interested party only by virtue of his filing of the certificate of acknowledgement 1 week before we began the notice process on the foreclosure sale. His name was picked up on a title report. He was sent notice of the foreclosure sale, and once the sale resulted in the purchase by Bulgaria, he was noticed on the interpleader action because his name came up on a title search. So that's the only reason why this came before the lower court and here. To reiterate counsel's argument regarding fraud and the interested party, I really don't have much to add to that. There are no particular allegations of fraud for which we can assert a defense to, and the law is clear that it has to be allegations made with particularity. Simply put, Mr. Whitsey is not really an interested party. He's only an interested party by his insertion into the process at the last second prior to a foreclosure sale. And I ask that the Chancery Court be affirmed, dismissing his claims based on his lack of true interest in the property. And I also ask that the court affirm the dismissal of his complaint based on fraud. And beyond that, I would rely on Mr. Morrison's brief and submit it to the court. If there are any questions.
I do have a question, but it's a procedural question. Are you on the brief with Mr. Morrison?
I am not.
Okay, you're going to need to file a notice of appearance then.
I will.
So that we'll be able to track who made the oral argument.
I will, Your Honor.
Okay. Thank you.
Thank you.
Mr. Whitsey, I believe you have 3 minutes, sir.
Now, I didn't get to make it through all my points because I was answering, all the questions. But pretty much their main argument here has been pretty much what I expected, trying to convince you all that I didn't have any claim of interest in the property when I've actually been the only one to provide any evidence for my claim of interest in the property. Their claim of interest in the property is entirely dependent on the agreement that they have not been able to provide any evidence or argument for. So this means by law that they have acquiesced and agreed to everything that I've said about the deed of trust. They're trying to actually convince you all that the fraud was not spelled out good enough, even though they have they've been shown in every conceivable way how the deed of trust was a fraudulent instrument, using the equity maxims, using state law, using federal law, using the deed itself. If I've come to borrow $200,000 from you, you're supposed to be giving me $200,000. It's not supposed to be me giving you $200,000 cash value. So the fact that they have not been able to prove that is evidence in and of itself independent of my claim to the title of the property. The deed of trust in and of itself is proof that they don't have any lawful claim of interest to the property. Now, he tried to, if you notice in their reply brief, they didn't give the actual definition of property, the state law definition of property. They gave their interpretation of the definition. In my briefs, I provided the actual verbatim definition of property. I didn't run from it. I didn't give some false interpretation. I gave verbatim what it meant and how it applied in this case. All of the parties of this case allegedly possess a fixed and certain interest in the intangible property that is held by government instrumentality, the Register of Deeds. Those properties include the deed and the deed of trust, both of which were held or are held by the Shelby County Register of Deeds. There is no getting around that. There is no escaping that. Now, with regards to my direct interest in the property, when a person goes to look for a new home to buy, they do their due diligence on the property. Who owns the title? Who allegedly owns the title? What does the public record say about this property? What does state law say about public records? What does state law say about the registration of these properties, of deed instruments? So as we've seen here, they have not been diligent in their administration of this property. They did not prove their claim of interest. They did not disprove anything that I've said. They did not prove that Tamika Cole didn't abandon the property. There are too many critical points here. In both cases where they brought up the Unclaimed Property Act and it being about custody, they proved exactly what I've been saying this entire time about the Register of Deeds being the holder of property. I rest my case.
All right, thank you, sir. We will take this matter under advisement and will attempt to render a written opinion as quickly as possible. We'll be in recess until the call of the docket this afternoon.
All rise.